Jay-Z has asked that a Texas attorney, Tony Buzbee, be sanctioned for filing a lawsuit against him, accusing him and Sean Diddy Combs of committing criminal acts against a 13-year-old girl, claiming that inconsistencies in the girl's story show that Buzbee knowingly filed a false complaint against him. So, in the sanctions motion that Jay-Z filed in New York federal court, Sean Carter, which is Jay-Z's given name, his legal name, asserts that a December 13th report by NBC News clearly established that several important details in the unnamed plaintiff's version of events are false. The NBC News report, for instance, included the girl's father saying that he had no recollection of picking her up from a gas station after she was allegedly assaulted by Carter and Combs, telling reporters, "I feel like I would remember that, and I don't." The girl is identified as Jane Doe in court filings. The court has given her permission to file anonymously. As Jane Doe's attorney, Tony Buzbee should have gone to far greater lengths to verify her story before filing suit, Jay-Z argues. The nature of the allegations here warrant sanctions, he says. This is not a contract dispute or a patent case. This is an allegation of some very serious, heinous crimes. At the very least, Jay-Z says, Buzbee should have withdrawn the December 8th amended complaint that first named him as a defendant when the NBC News report shot his client's narrative full of holes just a few days later. So Jay-Z is asking U.S. District Judge Annalisa Torres to dismiss the Jane Doe's claims against him and to force Buzbee to foot the bill for his legal defense. The sanctions motion is the latest escalation in an increasingly bitter feud between Carter, Jay-Z, and Buzbee that again began shortly after Combs was arrested on racketeering charges in September. So we're going to go through this memorandum of law that Jay-Z has filed, and he's asking the court to sanction Tony Buzbee, who represents this Jane Doe plaintiff. So we go through his table of authorities, cites all the cases that he's relying upon, the different rules of court, and here's the meat of it. So Jay-Z says that while the allegations stated in the complaint in this case are gravely serious and injurious to Mr. Carter's hard-won reputation, many of them on their face strain the outer bounds of credibility, and none of them appears to have been subjected to even the most rudimentary diligence by the filing attorney who initially signed his name to them and has since declined to withdraw them. Because the federal rules and professional ethics require more of a filing attorney, Mr. Carter now respectfully seeks appropriate sanctions. And then he talks about Federal Rule of Civil Procedure 11. That does require every attorney who signs a complaint to certify that to the best of the person's knowledge, information, and belief, formed after inquiry reasonable under the circumstances, the factual contentions have evidentiary support, or if specifically so identified, will likely have evidentiary support after a reasonable opportunity for further investigation or discovery. So this rule does not require attorneys to be perfect. It doesn't require attorneys to have all of the facts at the beginning before they file a lawsuit, because that's not possible. I mean, there are certainly going to be things that you need to flesh out and uncover in discovery. But the rule does require that the attorney conduct a reasonable investigation prior to filing a complaint against somebody. And Jay-Z is saying, listen, these claims really harm my reputation. They're very injurious to me. And Tony Buzbee did not do his due diligence. He did not take the time to look into the factual allegations that his client has brought. And he says this has all come to light because this NBC News report has really brought to light some holes in her story. And we've talked about this before on this channel. We've talked in great depth that, like, just because there may be some inconsistencies in her story, it doesn't necessarily mean that the alleged victim is lying. It doesn't necessarily mean that she has any malicious intent. Honestly, it could be that so much time has transpired since the alleged incident back in 2000. I mean, it's been almost 25 years since the alleged assault took place. And it's natural over time that memories wane, that different facts are going to be recalled or differently or not recalled at all. So that is somewhat standard in that there is sometimes these inconsistencies, and that's what does get fleshed out in discovery. It does get fleshed out at a trial where Jay-Z's attorneys will have the opportunity to cross-examine her. But Jay-Z is basically saying, listen, Tony Buzbee, he had the obligation and he didn't do his due diligence. And Tony Buzbee shot back and said, well, you know what? There was another firm that was handling the intake of this client who handled the drafting of that complaint. And Jay-Z's attorneys are saying, well, that doesn't matter. It doesn't matter if you had another law firm that referred you this case that handled that. You still have an independent obligation once you took on the case to research on your own and speak with this client and verify facts and see if what she was saying checked out. So listen, I understand both sides of the coin. I think both sides have merit and both sides have points to consider. So then they state, as judges in this district and elsewhere have long held, plaintiffs may not file a complaint in this court without having made a reasonable investigation of the facts. That rule accords with the rules of professional conduct, which prohibit an attorney from knowingly asserting material factual statements that are false, and from failing to correct a false statement of material fact or law previously made to the tribunal by the lawyer. So in addition to the court rules that govern our courts, there are also things called ethical codes of conduct, professional rules that govern the ethical conduct of the attorneys. And those things, the ethics rules govern things like conflicts of interest, or making sure that you have candor to the tribunal. And candor is truthfulness to the tribunal, making sure that you're bringing meritorious claims, not engaging in litigation for purposes of harassing someone else. So these are now what Quinn Emanuel, which is Jay-Z's attorneys, are tapping into and saying, hey, look, Tony Buzbee not only violated the court rules, but he also violated the ethical rules. And that's a very serious allegation. It can have impact for Tony Buzbee. So this memorandum goes on to state, those basic guardrails on litigation are critical to the integrity of the judicial process. Courts rely on attorneys to conduct a reasonable investigation into the facts alleged in a complaint to avoid wasting judicial and party resources litigating meritless claims. And then they cite a number of cases for this proposition. Plaintiff's lead attorney, Anthony Buzbee, has violated Rule 11B by either knowingly making false allegations about Mr. Carter in the amended complaint, failing to conduct an adequate investigation into the complaint's factual allegations, or at minimum, failing to withdraw the complaint once it became clear that numerous allegations in the complaint are false and the other allegations are therefore at least highly suspect. Okay, so then Jay-Z's attorneys go on to state that the First Amendment complaint alleges that following the 2000 Video Music Awards, plaintiff was assaulted at a celebrity party, but almost immediately after the First Amendment complaint was filed, NBC News journalists determined that a number of allegations were either false or highly doubtful. A news journalist, I don't know, they're saying that they determined that things were false. They didn't determine that things are false. The trier of fact will determine what they believe to be true or false. But the news journalists did highlight it did come to light after this NBC News article that there were some things that didn't make sense with the alleged victim's story. For example, paragraph 44 of the complaint claims that the party occurred at a large white residence with a gated U-shaped driveway that was approximately 20 minutes from the VMAs by car. But photographs show that after the VMAs, Mr. Carter attended a party at Lotus, a nightclub in New York. So Alex Spiro, which is Jay-Z's attorney, is saying, hey, look, he wasn't even at a residence that has a U-shaped driveway. He was at Lotus. Paragraph 60 states that after the alleged assault, plaintiff's father drove to pick her up. But her father has no recollection of doing so, despite the fact that it would have been a 10-hour drive round trip to retrieve his 13-year-old daughter from a random gas station. Paragraph 46 of the complaint states that plaintiff spoke to celebrities at the alleged party, but when journalists pressed her as to which celebrities she spoke with, she named a person who was in Chicago that evening performing a concert. Paragraph 40 states that plaintiff watched the VMAs on the Jumbotron. In fact, photographs from that evening show that there was no Jumbotron, as New York City had denied MTV a permit. And the same paragraph says the plaintiff approached limousine drivers at the VMAs, but video shows that the limousine area was cordoned off by police and inaccessible to fans. Now, it is possible that, it's possible that the alleged assault occurred, but maybe not at the event that the plaintiff is thinking. So some people have that theory. So then Jay-Z's memorandum goes on to state, by any objective measure, the fact that nearly every step in plaintiff's narrative, from her arrival at the VMAs to her interactions with the limousine driver and celebrities to the ride with her father, turns out to be false or highly unlikely, casts considerable doubt on plaintiff's allegations that Mr. Carter assaulted her, which he did not. Confronted with those glaring red flags, a competent and ethical attorney would have not only omitted the many erroneous allegations from the complaint, but also completed a thorough and careful vetting of the core assault allegation before affixing his or her signature to the complaint. Abiding by that ethical duty was especially important here, given the defamatory character of the assault allegations and the near certainty that the complaint would generate massive publicity in light of the identity of the defendant, inflicting irreparable reputational harm and forcing him to explain to his own children that he had been falsely accused of assaulting a child. And conducting a thorough inquiry is particularly critical, whereas here, the plaintiff has no corroborating witness for her account and claims that she did not tell a soul about the incident at any point in the last quarter century, including her father, who supposedly picked her up. So it appears that Mr. Buzbee failed to conduct any such inquiry, that a reporter was able to undercut almost all of the events of plaintiff's narrative just 5 days after the First Amendment complaint was filed, only highlights the complete lack of investigation undertaken by her own attorneys. A simple call to her father, a review of publicly available footage and photos from that night at and after the VMAs, or a review of publicly available property records would have quickly revealed the implausibility of her allegations. But Mr. Buzbee has all but admitted that he declined to undertake such a basic investigation. When confronted by NBC News journalists with the series of false allegations in the complaint, Mr. Buzbee sought to cover for his utter lack of diligence by claiming his client would undergo a polygraph examination. So he did say, hey, look, she'll take a polygraph. And then they said, well, but this is an offer that he seems to have abandoned since making it weeks ago. And he passed the buck, stating that another unnamed firm had vetted the allegations and that the Buzbee law firm would continue to vet plaintiff's claims and collect corroborating data to the extent it exists. That is entirely improper. And that I do agree that is improper if that's what happened. If Tony Buzbee was just relying on the firm that referred him this client to do the research and to do the investigation, that he has an obligation once he takes on this file to look into what they did and also conduct his own investigation and talk to the client and do some simple due diligence to see if things shape up as to what she's alleging. So So then it says it was Mr. Buzbee's responsibility to conduct a factual investigation into the allegations before he signed the complaint, not afterward. And he cannot evade that core ethical responsibility by relying on the work of other attorneys who did not sign the pleadings and are not associated with his firm, which is true. However, moreover, although Mr. Buzbee claimed in his statement to the journalists that his firm had interrogated plaintiff intensely, she admitted to the journalists that she had made some mistakes and was guessing about key details, serious problems with her account that Mr. Buzbee would have uncovered had his firm actually interrogated plaintiff. Well, I don't know, because I don't know about that, because if you recall, this plaintiff was 13 years old when the alleged assault took place. She alleges that she was drugged, that she took a sip of something at the party and then she felt like she had been drugged. It would be in these type of situations, especially with children, there is case law that says that we are more lenient as a court system. We are more lenient with children victims of not remembering certain details or having difficulties. And particularly in this case where she says like she was drugged, I mean, that causes a problem for her in one sense, because how could she then necessarily remember the identity of who allegedly assaulted her or what exactly happened. But what I'm saying is that it's not entirely unforeseeable that some of the details are fuzzy to her and that she may have to, guess on some of these details. But I also understand Jay-Z's point of view where he's saying, well, we're going off of this person who's, speculating, who's guessing on a lot of these key details, and my reputation is on the line. So I understand both sides here. So Jay-Z's memorandum of law goes on to state that instead of conducting a thorough investigation, Mr. Buzbee filed a complaint setting forth one of the most serious allegations of criminal conduct imaginable with an accompanying publicity campaign on social media and elsewhere, based on an uncorroborated claim of assault that relied on an easily disprovable factual narrative. And inexplicably, even though the NBC News story was published over 3 weeks ago, Mr. Buzbee has taken no action to withdraw a complaint that contains provably false statements. So they're really, Quinn Emanuel, who represents Jay-Z, is really putting a lot of pressure on Buzbee to withdraw the complaint. Every day that this complaint stays out there, it really harms Jay-Z, is what they allege. So none of these, so then Jay-Z goes on to state, none of that is acceptable for a member of the bar of this court or any other court. That is perhaps why Mr. Buzbee has not obtained admission pro hoc vice, despite having signed numerous pleadings and other filings in the 2.5 months since signing the original complaint. Indeed, although Mr. Buzbee advised the court on December 20th that he was admitted to practice in the Eastern District of New York and intended to apply for a reciprocal admission to the Southern District, he has not even sought interim admission pro hoc vice while his application is pending, despite signing more filings over the coming weeks. Whether that reflects an improper effort to avoid the jurisdiction of this court or just a failure to act with anything approaching reasonable diligence, it reinforces the propriety of imposing sanctions here. Well, this is interesting because when you're an attorney and you're admitted to practice in certain courts, you can actually ask to be admitted pro hoc vice to practice in a different court. And that's what they're saying he has not done. They're saying he has not really followed what would be standard practice or standard procedure. And so, which is an interesting point. Given the horrific nature of the allegations in the First Amendment complaint, every day this inadequately vetted complaint remains on the docket causes extraordinary harm to Mr. Carter, his family, his businesses, and his employees, especially when the complaint alleges violent, felonious conduct that is defamatory per se. Attorneys should not be permitted to destroy a person's reputation by alleging facts without a sufficient investigation or by failing to withdraw those allegations once it is clear that they are false or exceedingly unlikely to be true. Mr. Carter respectfully requests that the court vindicate Rule 11 by immediately dismissing the First Amendment complaint against Mr. Carter and imposing an inappropriate monetary sanction or fee award against Mr. Buzbee and the Buzbee law firm. So the factual background is as follows. On September 17th, 2024, federal prosecutors unsealed an indictment against Sean Combs for racketeering and other offenses related to sexual misconduct, none of which involved Mr. Carter. Shortly after that, Mr. Buzbee published a 1-800 hotline for potential plaintiffs seeking to sue Mr. Combs for abuse. So they're saying he was ambulance chasing. Just 2 weeks later, Mr. Buzbee stated in a press conference that more than 3,000 individuals had contacted him via the hotline, claiming to have been victimized by Mr. Combs. So then, Mr. Buzbee further stated that he has already represented 120 plaintiffs who intended to bring civil claims against Mr. Combs. That sequence alone strongly suggests that Mr. Buzbee's vetting of claims was grossly deficient. Even assuming Mr. Buzbee set up the hotline on the same day that Mr. Combs' indictment was unsealed, the sheer number of calls that Mr. Buzbee allegedly received within the 2 weeks between the unsealing and the October 1st press release indicates that Mr. Buzbee could not possibly have vetted every caller's allegations to the extent necessary to establish their veracity before signing up 120 of them as plaintiffs. I mean, that is an interesting point because, he's claiming he got flooded with thousands of calls on this 800 number. He's kind of doing a cattle call for people who were allegedly victimized by Sean Combs. And then he signed up 120. How could he have vetted all those claims unless he had just like an extreme amount of staff working, for him in those 2 weeks? It just does not seem likely. But within weeks of his press conference, and in an apparent rush to be the first attorney to get claims on file against Mr. Combs, Mr. Buzbee filed 15 lawsuits on behalf of individuals who contacted him via the hotline in this court alone. In addition to those 15 lawsuits, Mr. Buzbee also filed the original complaint in this case on October 20th, 2024. That complaint alleged that Mr. Combs, along with another unnamed male celebrity, assaulted plaintiff at a party hosted by Mr. Combs following the VMAs on September 7, 2000, while a female celebrity watched. In a letter dated November 5 and in subsequent telephone conversations, Mr. Buzbee threatened to go public with false and defamatory allegations that Mr. Carter was the other male celebrity who had assaulted plaintiff. So Buzbee sent a demand letter to Jay-Z saying, we want to resolve this privately with you. We won't name you officially yet. But unless basically the insinuation was, if you don't resolve this, you're going to get named. And that's exactly what happened, because Jay-Z called his bluff and said, I'm not going to pay you hush money. He filed a lawsuit against Tony Buzbee in Los Angeles County Superior Court. And he went on social media and attacked Tony Buzbee and said pretty aggressively, like, I'm not going to back down. So basically, he says that unless Mr. Carter agreed to pay an exorbitant sum in private mediation, Mr. Buzbee honestly threatened to take a different course if Mr. Carter did not commit to the mediation within a mere 2 weeks. Unable to extract a payment from Mr. Carter for the false allegation, Mr. Buzbee then filed the First Amendment complaint on December 8th, adding Mr. Carter as a defendant without, has now come to light, having undertaken even the most basic investigation of the allegation. The First Amendment complaint alleges that on or around September 7, 2000, a friend drove plaintiff from her home to Radio City Music Hall to attend the VMAs, where she remained outside and watched the event on a Jumbotron. During the VMAs, plaintiff determined to get into the VMAs or an after party, allegedly spoke with numerous limousine drivers to talk her way in until she spoke with a driver who informed her that she fit what Diddy was looking for. When the VMAs ended, the First Amendment complaint claims that the same driver took plaintiff to a party hosted by Mr. Combs at a large white residence with a gated U-shaped driveway and a large living room or foyer. At the party, the First Amendment complaint alleges plaintiff recognized many celebrities, which she told an NBC News journalist included musician Fred Durst and Benji Madden, among others. The First Amendment complaint then recites the same assault allegation as the original complaint and alleges that the previously unnamed male celebrity who also assaulted her was Mr. Carter. It states that following the alleged assault, plaintiff ran out of the house, passing numerous celebrities and other individuals on the way to a gas station where she called her father, admitted that she had lied about her whereabouts, and asked him to pick her up. Plaintiff's father then purportedly arrived to pick her up shortly before dawn. So, on December 13th, on December 13th, 2024, a plaintiff sat for an interview with NBC. That interview exposed that plaintiff had not, prior to that point, faced any meaningful scrutiny of her factual account. In response to questioning from NBC, plaintiff confirmed that many of the First Amendment complaint's allegations did not correspond with basic, known, and readily ascertainable realities. For example, NBC reported that photos of Mr. Carter from the night in question show him in Lotus, a nightclub, not a private residence. Other photographs from the evening also show Mr. Combs with his then girlfriend, the musician and actress Jennifer Lopez, at two different establishments, Lotus and Twirl, neither of which was a large residence with a U-shaped driveway. Plaintiff also claimed with certainty that she spoke with musician Benji Madden at the alleged party about his tattoo of the Last Supper. She supposedly remembers this interaction with clarity because she has a religious background, so it was something to talk about. But Mr. Madden was not even in the state of New York. His representative told NBC that he did not attend the VMAs and, in fact, was on tour in the Midwest with his band Good Charlotte. Plaintiff also asserted that when she could not gain entry into the VMAs on the night in question, she watched the award show on a Jumbotron outside. Photographs and video, however, confirmed that no Jumbotron existed as the city of New York denied MTV's permit request for one, and that when picking up or dropping off celebrities, limousines were cordoned off by police barricades inaccessible to fans. So one theory that has popped up is, did this assault occur but at a different VMA after party? Not the September 2000 VMA after party, but at a different after party. Because some of these details people are speculating might correspond with the, other VMA after parties on different years. All of this would have caused any reasonable attorney to put the brakes on filing an inflammatory complaint and to conduct a more thorough investigation into plaintiff's allegations. Such an investigation would have immediately led the attorney to the First Amended complaint's only identified witness of the alleged events, plaintiff's father. And even a brief call to him would have revealed, as the NBC News journalist immediately found out, that he was entirely unaware of the assault until the week he was interviewed and had no recollection of picking his daughter up at the gas station. Given that plaintiff and her father were living in Rochester at the time, a 5-hour drive to New York City, it is unlikely that he would have forgotten about the incident if it had actually occurred. He said to himself, "I feel like I would remember that, and I don't. That's something that would definitely stick in my mind." Though he recalled an instance where he picked her up in the middle of the night, he remembers it as a local drive, not to New York City. Uncovering these serious problems with the claim would not have taken a competent and ethical attorney much time. NBC journalists identified the complaint's factual inaccuracies only 5 days after the First Amendment complaint was filed. But despite engaging in maximalist efforts to solicit new clients through his 1-800 hotline and extract an outsized payment from Mr. Carter under threat of taking a different course if he did not acquiesce, Mr. Buzbee did not apply the same vigor to actually testing the specific allegations of plaintiff's case. Indeed, although Mr. Buzbee claims that his firm will continue to vet his client's allegations, he appeared to admit to NBC that his firm failed to conduct any investigation into the merits of plaintiff's claims in the first place. And that is problematic for an attorney. Like, that is going to serve problematically for him, I think, as this case moves forward. So then he states that Jay-Z states it would have been simple to call plaintiff's father, review publicly available property records, or use a search engine to find photographs and videos of the VMAs from the night in question. But Mr. Buzbee apparently did not undertake even these basic steps. Instead of providing any justifiable basis for this complete failure to comply with Rule 11, Mr. Buzbee has sought to shirk his Rule 11 obligations and foist blame onto another law firm, telling NBC, "Jane Doe's case was referred to our firm by another, who vetted it prior to sending it to us." He also attempted to make up for his own lack of diligence by volunteering that his client would undergo a polygraph examination, but despite his routine social media updates about this case, he has been notably silent about whether plaintiff has sat for the polygraph test or what the results were. Following the publication of NBC's article on December 13th, Mr. Carter filed a pre-motion letter informing the court of his intention to immediately file for sanctions to dismiss plaintiff's First Amendment complaint and requesting that the court shorten Rule 11's 21-day safe harbor period to 1 day in light of the extraordinary and ongoing reputational harm inflicted by the complaint's false allegation of sexual assault. 4 days later, Mr. Carter served a copy of his motion on Mr. Buzbee and all counsel of record via email. So he followed through. Quinn Emanuel follows through. Quinn Emanuel is the law firm that also represents Alec Baldwin in his complaint against prosecutors for the Rust shooting charges that they brought against him. So now, though the court denied Mr. Carter's request to shorten the filing deadline, it permitted him to file this motion in compliance with the rule's safe harbor period. Since December 17th, Mr. Buzbee has not sought to withdraw the First Amendment complaint during the 21-day safe harbor period provided by Rule 11. So basically, the safe harbor period, it gives him 21 days to go ahead and withdraw his complaint and make things right. And if he doesn't do that, he's going to potentially face some consequences here. So the NJZ's attorneys set forth their legal argument, and they talk about the rules that govern the court. They've said that not only has he violated Rule 11, but they also believe that he has violated professional ethical conduct rules. The first part of Jay-Z's argument states that the court should impose Rule 11 sanctions for Mr. Buzbee's filing of the amended complaint and refusal to withdraw it. He violated Rule 11B by either filing a knowingly false complaint or failing to conduct a reasonable inquiry. Mr. Buzbee signed a First Amendment complaint containing extraordinary, serious, and defamatory claims against Mr. Carter. Because so much of the narrative set out in the complaint is demonstrably false and other allegations are highly unlikely, it is clear that Mr. Buzbee either knowingly filed a false complaint or failed to conduct a reasonable inquiry into the factual allegations. Mr. Buzbee all but admitted that he failed to vet the complaint and was still searching for corroboration of the allegations, casting the blame on an unnamed law firm that referred him the case. Yet weeks after the interview aired, Mr. Buzbee has failed to withdraw the First Amendment complaint or even more move for admission pro hoc vice, underscoring that he has simply ignored the basic ethical responsibilities required of a lawyer practicing in this court. So those are some very serious, strong allegations that the Quinn Emanuel team is asserting against Buzbee. And this really has turned into a lot of mudslinging, attorney versus attorneys. It's clear from easily ascertainable information that numerous allegations in the complaint are false or highly doubtful. By all indications, Mr. Buzbee did not conduct a reasonable investigation into the facts before signing the complaint, including the core allegation of sexual assault. First, photographs obtained by NBC from the evening in question make plaintiff's allegations implausible in the extreme. According to the First Amendment complaint, the assault occurred at a party hosted by Mr. Combs in a private residence. But NBC reported that photos of Mr. Carter from that evening show him at a party at a completely different location, the now closed Lotus nightclub in New York City. The First Amendment complaint's description of the location where the party and purported assault occurred, a large white residence with a gated U-shaped driveway, which included a large living room or foyer, and a hallway containing several rooms off of it, including a bedroom, bears no resemblance to the location or venue of the party where Mr. Carter was photographed that night. So they're saying, listen, she's got the location wrong. That's what they're saying. She's got the who, what, when, where, why wrong. The location is wrong. So moreover, Mr. Buzbee made clear in a statement to NBC that plaintiff does not claim the assault occurred at Lotus nightclub. Well, that's where Sean Carter was pictured to be, photographed to be. So second, the First Amendment complaint's account of what happened at the party before the alleged assault crumbled under even surface-level scrutiny. The First Amendment complaint alleges that upon arriving at the party, plaintiff encountered many celebrities in the large living room or foyer of the house. But when asked about whom she spoke with, she named Benji Madden, a conversation that supposedly stuck in her mind because of his readily identifiable tattoo of the Last Supper. That entire exchange, however, was pure fiction. Mr. Madden did not attend the VMAs that year. He was not at any party that evening and was not even in the state of New York. He was halfway across the country on tour with his band Good Charlotte in the Midwest, performing a concert in Chicago on the evening of the VMAs, a fact that a Google search would have revealed in less than a minute. A competent lawyer would have asked the question, whom did you speak with at the party, during the first substantive discussion with plaintiff about her claim, and then undertaken an effort to confirm that those individuals were indeed in New York that evening. But Mr. Buzbee apparently did not even bother to take that simple first step to investigate the claim before signing his name to a pleading accusing another person of a serious criminal offense. That is not how attorneys are supposed to conduct themselves. Now, what do you guys think? Do you think that he had an obligation to go and research, who was at this party? I agree that would have been a diligent thing to do, but is it a reasonable thing to do? And I think the fact that we're talking about celebrities, it's a lot easier to determine a celebrity whereabout. Like, for example, because Benji Madden, he goes on tour. So his location can be readily traceable and placeable. So so Jay-Z is saying, hey, look, he wasn't even at the VMA after parties that year. So let me know in the comments what you guys think. And then third, it says Mr. Buzbee evidently did not even contact the one witness that he both knew about and had access to, plaintiff's father, who was more than willing to discuss the matter with NBC News. And when he spoke with NBC, he disputed a critical element of plaintiff's story, how she got home. The First Amendment complaint alleges that after the purported assault, plaintiff ran to a gas station, called her father, admitted that she had lied about her whereabouts, and asked him to pick her up, after which he arrived to pick her up shortly before dawn, and the two drove home in silence. When asked about that claim, however, plaintiff's father told NBC that he had no memory of this drive ever happening, even though it would have involved a 10-hour round trip to pick up his 13-year-old daughter from a random gas station. And like virtually any other parent, he was confident he would have not have forgotten such an incident. I feel like I would remember that, and I don't, he told NBC News, even though that's something that would definitely stick in my mind. It is extremely unlikely that had Mr. Buzbee spoken with plaintiff's father as part of a reasonable inquiry into the claim, that the First Amendment complaint would have alleged that he picked her up. The logical takeaway is that Mr. Buzbee elected to file the First Amendment complaint without even finding out whether the only identified witness, apart from the anonymous female celebrity, could confirm plaintiff's story. Fourth, the First Amendment complaint contains other allegations refuted by publicly available sources. For example, it claims that plaintiff watched the VMAs from outside Radio City Music Hall on the Jumbotron and spoke to limousine drivers to try to talk her way into the party, but photographs established that no such Jumbotron existed. NYPD confirmed that MTV's permit request was denied by the city of New York, and if plaintiff had been outside the VMAs as she claims, there was no way she could have approached celebrity limousines because they were only outside of Radio City Music Hall briefly for celebrity pickup and drop off, and any event were separated from fans by police barricades, as publicly available video of the event shows. So they're saying, hey, look, there's a lot of Jay-Z's attorneys are saying there's a lot of factual inaccuracies here. There's a lot of factual inconsistencies here in what her complaint states and what the NBC News report ultimately had revealed. So these are very interesting points, and let me know in the comments what you guys think about these glaring inconsistencies in her complaint. A lot of people are saying, well, you know, she was only 13. She alleges she was drugged. It would be normal that after 24 years, her memory would fade. There would be some, you know, inconsistencies. And the law does recognize that for child victims, we are more lenient because their memories are going to have gaps in them. But then on the other hand, we also can understand Jay-Z's point of view, which is that number one, this person is remaining anonymous. She's not even identifying herself to him, so he can't really fully defend against these allegations. And I do see his point that Tony Buzbee does have an obligation to vet these claims. Even if a different law firm referred him the case, he has the obligation to vet these claims himself. And maybe some of the allegations in the complaint would not have been written as they were written if he, you know, that's what Jay-Z is claiming, if he had done a better job in conducting an investigation. So this unethical misconduct is compounded by the nature of the allegations here, given the gravity of the claim that has been made and the likelihood that its public airing would harm Mr. Carter's reputation and inflict emotional harm on third parties like his children. An ethical attorney would have conducted an especially thorough pre-filing investigation of plaintiff's claim. So these are like particularly serious and egregious allegations. And Jay-Z is a family man. He's built a reputation of being a businessman and having, a beautiful family with his wife Beyonce. He's got kids he has to answer to. So I mean, so listen, my heart goes out to both sides here. Because we don't know what happened. We don't know all the facts, and you got to have empathy for both sides here. So let me know in the comments what you guys think. And subscribe for daily live streams on this case, because we've been covering every pleading in this case, every major pleading. We've been covering this case since inception. So go ahead and subscribe here for daily live streams on the Tony Buzbee, Jay-Z, Sean Diddy Combs legal drama. We've also been covering Vanderpump Rules, the Ariana Madix, Tom Sandoval, Raquel Leviss case. Notably, Raquel Levis's lawyer, Brian Friedman, is also the lawyer for Justin Baldoni in his legal battles with the New York Times and with Blake Lively. We've been covering all of those stories as well. So guys, we've also been covering Brad Pitt and Angelina Jolie. So go ahead and hit subscribe and support our channel for ongoing daily live streams on these celebrity legal news. I look forward to joining you guys again tomorrow. I'll be back on live stream, but just suffice it to say, it will be very interesting to see how the court rules on this memorandum in motion that Jay-Z has filed. He wants sanctions to be held, to be given by the court against Tony Buzbee. Thank you guys so much. I look forward to seeing y'all again tomorrow.